The decision on whether Brian Walsh's Google searches will be admissible in his trial just recently came down. Now, we did some videos breaking down the arguments of what the defense was for Brian Walshe, why these Google searches should not be admitted. So let's just briefly revisit some of the arguments, and then we'll see what the judge's legal analysis is and make sure that everybody understands where she's coming from. And I'll tell you ultimately whether I agree with it or not. So the issue was that when the troopers downloaded Brian Walsh's devices, they did not have a search warrant. Okay, so very clearly, that is undisputed. They did not have a search warrant when they downloaded. They did a full download of his devices, his phone, his iPads, his children's iPads. They did not have a search warrant. Okay, so that's obviously going to right away create a problem because you need a search warrant. Otherwise, we have Fourth Amendment rights, which protect every single individual citizen of this country from unreasonable searches and seizures. So that's where this analysis begins. So what are the possible arguments to get beyond this fact that there was no search warrant when they performed the download of his devices and they found all these incriminating searches done on his device? So the first argument that the Commonwealth makes is that there was consent. You don't need a search warrant if the person consents to you downloading or the police downloading their devices. And after all, here they had Brian Walsh's consent. That is argument number one. Argument number two, and this is really what it all comes down to. I know there's some other legal arguments, but this is really what it comes down to. That's number one, there was consent. Number two is that even if there was not consent for this full system download, full download of the phone, but still it would have inevitably been discovered. The police in their investigation would have inevitably, ultimately had to download all these devices anyway in furtherance of their investigation. And therefore, just because they happen to have seen what he downloaded before they technically had a search warrant, it doesn't really matter because there's a doctrine called the inevitable discovery doctrine. So these are the two theories that the Commonwealth argues why, even though there was no search warrant when they downloaded these devices, still all these searches should still be admissible. They should not be suppressed. So now let's see how the judge deals with these two arguments. Now, also something just you have to understand for background is that there was extensive evidentiary hearings on this issue. So there were evidentiary hearings. That means that certain judges do hold evidentiary hearings when you have these important issues that are brought in front of us. Now, we saw what happened with the Karen Reed case, but here you actually have a judge who realized that they should have an evidentiary hearing. They had evidentiary hearing. They had Yuri Buchanan on the stand. They had Lieutenant Fanning on the stand, and they even had Brian Walsh's criminal attorney for the federal case that he's facing. They had her on the stand also. Now, we're not able to see her testimony. At least I didn't see it. But they also got her on the stand. Now, she submitted an affidavit as well. And in that affidavit, and this is really very important for this, in that affidavit and even on the stand, this attorney said, Tracy Minor, that the consent was limited to communications, which means that just because the police have consent for a certain scope, they cannot exceed that scope saying, well, you consented to us looking at your phones. Yeah, well, I only consented, let's say, for text messages. So if I only consented for you to look through my phone for text messages, you cannot go and look at my phone, my call log. You can't look at my Google searches. So what was the scope of the consent? And this is where the attorney who negotiated the consent, who negotiated these downloads, said and testified under oath that in her mind, her understanding was that the searches, the download was going to be limited to communications. Now, also something you have to understand before we get to the opinion is that when there is ambiguity about what the scope is, that ambiguity is in the favor of the defendant. So anytime there's an ambiguity, it has to be looked at in favor of the defendant's constitutional rights under the Fourth Amendment. And therefore, if there's some ambiguity about what the scope is, then you have to limit the scope up to what there was no ambiguity about. So this is where you have a real interesting issue with this case, because you have his own attorney getting up on the stand, and this is not a newbie attorney. a very experienced attorney who's negotiated these type of deals all the time. And she said very clearly that my understanding was that the scope of the search, the scope of the consent was limited to just communications on the phone, not Google searches. Okay, now you see why this is becoming a little bit of a problem. Definitely when it comes to the consent part of the argument. Okay, so with that background, let's pull up the opinion, and we're going to only read through certain parts of it, the parts that I think are really important and relevant for this discussion, and hopefully we'll get a good understanding of what this judge's ruling is. Now, the first thing that I want to point out is that you guys all know how much I love footnotes. A lot of times you have some juicy stuff in the footnotes. They're very overlooked, but sometimes you get some good nuggets here. So let's first start with a nice, cute footnote here by the judge. And here, the judge says, look at this footnote, the defendant argued at hearing that the Commonwealth must prove consent beyond a reasonable doubt. In his written pleadings, the defendant provided no case law to support the standard. And you know, on this channel, if you don't provide case law, then you may as well just abandon the argument. So that's the first strike against them. And now the judge says, in fact, they're wrong. In fact, the case law refers to the preponderance of the evidence standard applying to consent searches. So actually, it's not beyond a reasonable doubt. It's actually a preponderance of the evidence, which is a much less of a burden for the Commonwealth. Okay, so the Commonwealth just has to prove that there was consent by a preponderance of the evidence. That's an important part, because when you have one attorney saying, look, this was not the scope of the consent, that right away could be reasonable doubt. But once you start talking about preponderance of the evidence, well, if you have a lot of other evidence on the other side, which shows that there was consent for a full system download, a full phone download, well, then you can say, okay, well, the preponderance of the evidence tells me that there was consent and the scope was to include Google searches. So that's a very important part, which a lot of people may have missed because it's in the footnotes. So if you're from my channel, you know you read the footnotes first. But anyway, okay, let's move on. So now let's go down to these two issues. Now, there's an extensive background of all of the facts in this case, the coming and goings and the different interviews that were done. And it's interesting if you want to understand the background of the case. But I think for the purposes of our video, we don't really need to get into all the nitty-gritty of when in each interview happened. What we have to know is that there were communications between Brian Walshe and the police without his attorney there. Okay. And again, this is an attorney that's representing him in the federal case. So it's not like they were doing anything wrong by interviewing him, because that attorney is for a different case. So these communications, these interviews that happened between Brian Walshe and Trooper DiCiccio, for example, and Buchanan and Proctor. So those communications happened. And in those communications and on a number of different interviews, Brian Walshe came across as very much trying to help the police, very much as if he had no idea what happened to his wife and that he really very much wanted her to be found. A very caring husband. That's how he portrayed himself anyway. And a lot of times he said, yeah, I'll do anything. You can look through my phone. I'll give you what you want. But actually, when it came down to, okay, we're going to need to do a full system download, a full download of your phone, that's when he actually pulled back a little bit. So again, we're not going to get into the weeds here, but really that's a lot of what this opinion is based on. The fact that Brian Walshe was very much trying to work with the police. That's the impression that he gave, that he's just willing to do anything that it takes to find his wife. Okay, so now let's take a look at this part, because really it comes really more down to what did this attorney actually say, because she was the one who negotiated it. Because at the end of the day, he did say to the police, look, I'm not consenting to a full system download just quite yet, because that's a lot of information that you want. I need to speak to my attorney. He handed off the negotiations to the attorney. The attorney negotiated with First Assistant District Attorney Lynn Beeland, and that's where Brian Walshe left this. I'm going to leave this in the hands of my attorney, and she's going to negotiate what the consent or what the scope of the search is going to be. So that right away throws a little bit of curveball into all of the context in which this judge is going to be referring to, the context in that initial conversations with Brian Walshe and the police, where they're saying, yeah, we need to find anything that's related to Anna, which would not just be communications. A lot of what she's saying has to do with those communications that Brian Walshe and those interviews that Brian Walshe had with the police. But still, the way that conversation concluded was, I need to speak to my attorney. And then he handed off the negotiations to the attorney. So really, how much can you glean and use that context of whatever Brian Walshe spoke to the detectives and to the troopers when his attorney wasn't even there? Okay, but anyway, let's see what the judge has to say. The defendant argues that Attorney Minor negotiated the scope of the search with FADA Beeland and that their agreement only concerned communications on the devices. However, FADA Beeland merely memorialized the already agreed to terms of the consent agreement between Sergeant Buchanan and Attorney Minor. And Buchanan said, and he testified, now whether you believe him or not, that's your own choice, but Buchanan testified that no, in fact, he did tell Tracy Minor that, and the attorney, this is Attorney Minor, he did tell her that there's going to be a full system download. It's going to be a full download of the phone, including Google searches. That's what Buchanan testified to. And therefore, Beeland is just memorializing the already agreed to terms of the consent agreement that Buchanan negotiated with Attorney Minor. Now, again, it's always interesting because when you have an attorney and you have another attorney, usually attorneys negotiate things with other attorneys if there's an attorney involved. So here you have Beeland, right? First Assistant District Attorney Lynn Beeland, and therefore she should be making sure everything is spoken about with Attorney Minor, right? If that's usually how attorneys work. If we're negotiating, we don't negotiate with the police, we negotiate it with another attorney. If there's no attorney, then we may negotiate with the police. But anyway, FADA Beeland's email noted that any conversation between the attorney and client Brian Walshe and any conversation between Brian Walshe and his wife Anna Walshe on the week before she was missing shall be excluded from the search and examination of Brian Walsh's phone and TW's iPad. That's the son's iPad. So that was what was memorialized. So they're quoting, the judge is quoting directly from the email. And the email just says what's going to be excluded from the search. And it says any conversations between Brian Walshe and his wife before 12/25 and also attorney-client privilege. Any conversation between the attorney and client Brian Walshe. Attorney Minor responded, we consent to all communications on or after 12/25. If you want to go back further than that, I will have to get you a list of attorneys as he has used a bunch of them. Nothing in this exchange, says the judge, limits the search and examination of the phone and iPad to only communications. Rather, the email refers to the exclusion of communications subject to attorney-client or marital privilege, material that typically would be excluded from the search of a device capable of containing such communications. Given the content of the email exchange, noting only what should be excluded from the search of the phone and iPad, along with the previous discussions, again, this is where she's relying on the previous discussions about the extraction of all the data, a typical reasonable person, and that's really what it comes down to, the case law, what would a reasonable person understand of the scope of the search? So the judge is saying that given the content of the email exchange, which is only saying what we're excluding from the search, it doesn't say that the search is limited to only communications. That's not what it says in that email. So, and also taking into account the previous discussions about the extraction of all the data that was told to Brian Walshe, a typical reasonable person would not have understood the emails to be limiting the search to just communications. Now, the defendant also contends that at the very least, the scope of agreement was ambiguous, and that ambiguity should weigh in favor of the defendant and against the Commonwealth. And that is what the case law stands for. If there's ambiguity when it comes to a Fourth Amendment right, then we always are in favor of the defendant. It is certainly true that the requirement of reasonable clarity applies to the scope of consent, and that if the court is unable to discern the scope of consent because the agreement was ambiguous, then the search should be deemed unlawful. So there you go, saying if there's any ambiguity, then the search is deemed unlawful. However, the scope of consent in this case was not ambiguous. The police explained in no uncertain terms that they were performing a full data extraction of the devices and looking for information to assist in locating Anna. Now, those were communications that were made to Brian Walshe, not to the attorney. They explained their intent to create a timeline using data showing the last time Anna manipulated TW's iPad, which was in the early morning of January 1st, sometime around 6 a.m. That's what TW's statement was. The discussions about limiting their search only concerned communications subject to attorney-client privilege and those between Brian and Anna before December 25th, 2022, and the actions of the police, Brian and Attorney Minor, reflect an agreement to consent to a search of the phone and iPad for any information in the agreed-upon time frame that could assist with locating Anna, excluding only the information communications. Even if Attorney Minor believed she was consenting to a search only of communications in the device, which is what she testified to, the court's inquiry here is as to what a typical reasonable person would understand the scope of the consent to be based on the totality of the circumstances. Based on the overall context of the encounters with the police in this case, an objective observer would not perceive the search as exceeding the scope of defendant's consent. So, do I think this is a little bit of a stretch? Yes. Do I think it's an abuse of discretion? No. So, I don't know. You know, when you have communications between, again, like we said, Brian Walshe and the police, and then the Brian Walshe very clearly said, look, I'm not agreeing to anything until I speak to my attorney. So even though you're right, the police did tell him, we need to find Anna, and anything's going to help, we need to find Anna. And initially he seemed to saying, yeah, that's very important. We need to find Anna, and I'll do whatever I can to help. And here, look through my phone right now. But then when they said we need to do a full download, that's when he started hesitating. And he said, okay, I'm going to turn this over to my attorney. So really, what type of context and totality of circumstances can you use from his communications or his interviews with the police as it relates to what the consent was? He handed off the consent issue to his attorney. And then the attorney said under oath that her understanding was it was only limited to communications. And the email itself that is not 100% clear, well, maybe that can be an ambiguity. And if it's an ambiguity, it's not clear 100%, well, then it should be in favor of the defendant. So I can't say with confidence that I agree completely with this analysis. I don't think it's an abuse of discretion. I think I understand where she's coming from. I hear the arguments, but I can definitely also hear the argument the other way. Okay, so that's in terms of the consent issue. Now, one of the good points that she brought up actually was the fact that if the iPad, which was communicated to Tracy Minor that was going to be searched, there's no communications on an iPad. Right? There was no communication. So what does she think is going to be searched on the iPad? And by the way, on the iPad is where all these Google searches were found. It wasn't from his phone. It was from his son's iPad. So if Tracy Minor knew that the iPad was going to be searched, what does she think that was going to be limited to communications? And it could be she can say, well, I maybe some people on their iPad are able to connect to their phone and they have communications on their iPad also. That could be. Some people have that. So again, I'm not overly convinced with this analysis, but I see where she's coming from. Okay. Now let's move on because this whole issue may just be a distraction because we have the next part. And the next part is the inevitable discovery doctrine. We spoke about this also again in the beginning of the video, which has to do with if this is going to be turned over anyway. Now, why does it come up in this specific case? The reason why it comes up is because they were in the middle of conducting a missing persons investigation. After all, that's how this investigation got kicked off. It wasn't a murder investigation. It got kicked off as her employer called her in as saying that she's a missing person. So where is she? That's what started this all. So they're conducting a missing persons investigation. And during that investigation, that is where Brian Walshe told them some untrue information. And then once they were able to see that Brian Walshe was not being forthcoming with them as it relates to their missing person investigation, so as a result of that crime, misleading the police, well, then they could also have requested search warrants and searched his phones and devices to find out where Anna Walshe is as part of that investigation and a part of his investigation of misleading the police. So both of those investigations could come into play here where they would have inevitably discovered these Google searches anyway, even though technically you're right. When they did discover it, it was based on him handing it over and part of the consent. But if inevitably it would have been discovered anyway, so then that's where the second part, the second argument and decision comes from. So now take a look at this. Here, even assuming that the police exceeded the scope of the consensual search, which I think there's definitely a strong argument to be made. After striking the references to the internet searches and location data discovered during the search of the full extraction of the two devices, the information remaining in the search warrant affidavit provided probable cause to believe that the defendant misled the police in its investigation into Anna's disappearance. Now remember, they discovered this. This is according to the evidentiary hearing. And if you read the entire opinion, all 31 pages, you can find this also, but I'm not going to do that to you. What you can find is that the police said that they figured out that Brian Walshe was lying to them and misleading them before they found any Google searches. So they figured this out on their own. So, to believe that the defendant misled the police in its investigation into Anna's disappearance and that electronic devices that contained evidence of the same would be found in the Walshe residence. This includes Brian's false statements about his whereabouts on January 1st, 2023, because he lied about it. TW's is the account of what Anna last touched his iPad and left the home. So remember, the child here, the 6-year-old, told the police that he saw Anna last at 6 o'clock in the morning. And this is a big question in this case. If Brian really did something to her, why would the 6-year-old have a memory of her leaving the house at 6 a.m. if that never happened? And what the prosecution seems to, their case is going to be, is that Brian coached his 6-year-old to lie to the police. That's what seems to be the prosecution's case about that. But anyway, even if they were to assume that actually he was saying the truth, this 6-year-old, and he wasn't coached, well, his account was that morning Anna touched his iPad when she left. So therefore, they're in the middle of a missing persons investigation into Anna, and the last thing that Anna touched was his iPad, then that would also be reason why they can search the iPad, and that is the iPad where they found all of these Google searches. Continuing, Brian's account of why he did not contact the police to report Anna missing and his subsequent communications to Anna and others about her disappearance when he found his phone and information concerning the return of Brian's phone and TW's iPad to the home on January 7, 2023. The terms of the warrant would have authorized the police to search for electronic devices in the home, particularly those known to be manipulated by Anna and or used by the defendant. Thus, discovery of the electronic searches and location data was certain as a practical matter. So which means is that under the inevitable discovery doctrine, they would have gotten a search warrant to search the devices, and pursuant to that search warrant, they would have discovered these Google searches, which would have been included in them being able in the search warrant for the missing person and misleading the police, and therefore they would have discovered these searches anyway. So under the inevitable discovery doctrine, that's what the judge is saying anyway. Even if there is no consent, it still would have been discovered, and therefore that is why they are admissible, all these Google searches. So for that part of the analysis, I 100% agree. I think she got that 100% right, nailed it, and there's definitely some very strong indications that there's reason to be able to obtain through search warrants, through probable cause, that iPad, which eventually showed the searches, had something to do with her disappearance, or they needed it for the investigation into her disappearance, and also the fact that Brian Walshe was misleading the police to be able to get his devices and see what he was doing while he's trying to mislead the police. So all of those would have come in anyway through the inevitable discovery doctrine. So I think that the analysis on that is pretty strong, although the analysis on the consent I don't think is amazing. Nevertheless, it doesn't really make a difference because once they come in through the inevitable discovery doctrine, it doesn't really matter so much about her analysis, whether it was correct or not about the consent. So therefore, the conclusion is that these Google searches are going to be admitted. And that is a great, great win for the Commonwealth and probably for justice, because if he would have gotten off on this technicality and, you know, his chances of acquittal would have gone way up through the sky. So I don't know exactly what the defense is going to be at this point. Somebody else did the Google searches. I don't know. Well, I guess we're going to have to find out during the trial, but a tremendous victory for the Commonwealth, despite all of these issues that came up with those searches and not having a search warrant and making sure that the consent is clear and what the scope of the search is under the consent. Despite all of that, these searches are going to be coming in Brian Walshe's case. So that is going to be it for today on this issue. And hopefully by now you have subscribed. If you haven't, please subscribe and like the video, and we will see you next time.